Okay, we're on the record in People versus Jared Miller, file number 256837. The record should reflect Mr. Miller's present here in the courtroom today. If I could have counsel put your appearances on.
For the record, good morning, Your Honor. Mike Roland.
Good morning, Judge Larry Brown, on behalf of Mr. Miller.
All right, this is the date and time set for sentencing in this matter. Mr. Brown, did you have a chance to go through the pre-sentence report with Mr. Miller?
I did, Your Honor.
And Mr. Miller, did you have an adequate opportunity to go through that report and talk to Mr. Brown about it?
Yes, Your Honor.
Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor, and no challenges to the score.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, lists, or corrections, but we do have a victim who would like to speak.
Okay, do you have any challenges to the scoring?
No, Your Honor.
Mr. Miller, if you'll have a seat there next to your attorney. And Mr. Rolla, if you hand the victim.
Yes.
Please. And we'll come right to the podium. And we had a trial in this matter. And your name was certainly put into the record during the trial as a witness. But if you could just state your name again here today.
Samantha Badgley.
And Ms. Badgley, I did have a chance to read the written victim impact statement that was submitted. What would you like to say here today?
I have something written down. Should I just?
Sure.
Okay. I'm here today to express the impact that the situation has had on my life. The financial strain caused by the theft I experienced has not only affected me, but also my child. As a single mom, I am solely responsible for supporting my family. So to address necessary repairs needed on my home, I had to take out a loan. And the burden of making these monthly payments on this loan for money that was essentially stolen from me, as well as having a roof that is still declining over time, has further strained my already limited financial resources, as well as being a constant source of stress for me. As time goes on, my roof is getting worse and I don't have funds to repair it. And the longer I wait to repair it, the more damage is done to my home. If Jared had not stolen this money from me, or even if he had given me money back, my roof would have been able to get done. But now, because there is more damage, I will have to come up with even more money to repair it. The situation has left me feeling vulnerable and overwhelmed as I strive to provide a safe and stable environment for my child. I respectfully urge the court to consider the ongoing struggles that I face because of this crime. Thank you for your time and consideration.
Thank you. Appreciate that.
Thank you.
Mr. Miller, you can come back to the podium. Mr. Rolla, is there anything that you would like to say on behalf of the people?
Yes, Your Honor. Thank you. It's a first felony situation with guidelines of 0 to 5 years. There's a recommendation of 2 years probation with jail for 3 months, which would be the top of the minimum guideline range. In this particular case, as the court's well aware, the jury took 14 minutes to find the defendant guilty in this particular case. A situation where this defendant had over a year to simply perform the work he had agreed to do, that he had contracted for, and or then refund the victim's money. And we would have never been brought here before the court. The victim is Bagley, as she already indicates, a single mother. It's unfortunate that in his written statement as attached to the PSI, this defendant tries apparently to portray himself as a victim by indicating that on August 3rd or 4th, due to, quote, lack of a crew to help me, which was likely because of cold months coming, and other jobs taking longer, he couldn't do the work. Then stated he has a 5-star rating. And quite frankly, Your Honor, people submit is evidenced by the fact in this particular case, in addition to August being a summer month, not a colder one, of course, that the defendant also in this particular case, you should recall, as the jury was told, he wanted payment not made to his company, but to himself and or in cash. No work ever being done, no supplies ever being delivered to the victim. And then when the victim, as you recall, that she testified to, tried to make arrangements to get this done, he just ghosted her after that particular fact. So quite frankly, in people's position, the defendant's actions are completely contrary to his claim that at no point did I intend to defraud anyone. But the fact that over a year has passed without this matter being remedied, and the facts as determined by the jury, I was wrong, it was 18 minutes, not 14 minutes. His own actions would seem to indicate otherwise, in which case, although this is the first felony and it's unusual, it would be the people's position that we think jail time should be imposed. Thank you, Your Honor.
Thank you. Mr. Brown?
Thank you, Your Honor. I did have an opportunity to speak with Mr. Miller. Firstly, I do feel bad and have sympathy for Ms. Badgley. I know what kind of a position that put her in. I spoke with Mr. Miller about that and essentially tried to have him imagine himself in that position if that had happened to him, because he does have a family. He's 28 years old, no prior criminal history at all. This is not a drug-related crime. It's not a violence-related crime. And he has 2 children who are on the spectrum, I believe, and another one on the way to be born very soon that he is desperate to see the birth of. If someone were to do that to him and he depended upon that service. And I don't really think he understood that before he looked at it from that kind of a perspective. The court will note that he has steady employment, he has steady residency. And again, this is his very first offense. And looking through this and reading the PSI, I did get a copy of this statement and go through that. He does have an 8th grade education. He dropped out of high school because he got his girlfriend pregnant. He dropped out of high school and went straight to work and tried to do the right thing by taking care of the family. There was no indication that he's bad at his job as far as his workmanship goes. But unfortunately, being skilled at something, you can be the most skilled person in the world at construction and roofing. But if you're going to run your own business, there are certain things you just got to do. And he has no business experience and does not know how to run a business. I understand what he said, that at no time he intended to defraud anyone. And that may be well true in his mind. But again, nobody can read somebody's mind. The only way we can determine intent is through facts, actions, things that we can present, that a jury can see. So while he still believes and maintains that he did not intend to defraud, he does understand and can see with the evidence that was presented, how a jury could look at that and say, yeah, this just does not look good. This doesn't look good. I don't think he's doing it in order to try and raise sympathy for himself or anything of that nature, Your Honor. I think it is just a lack of education, perhaps ignorance in running a business, and believing that all of these things through his life experiences, the loss of his son, for one, and these are just things that maybe he even assumed somebody would have understanding about in his mind, not really looking at it from an outside point of view of what this really looks like. I don't think he's a really bad guy here. He intends on paying every penny of this back as soon as feasibly possible. I believe he might have a large portion of it today. So I would ask the court to take all those things into consideration when fashioning a sentence here. If the court does impose jail time, Your Honor, I would ask that the court consider holding it in abeyance or perhaps under a delay so that he can get out there, get to work, and get this paid on. Thank you.
Thank you. Mr. Miller, is there anything you wanted to say today?
Yeah, I just wanted to apologize. I didn't intend for any of this to happen. At the time I took the job, I thought very well I could get it done in a timely manner. Wasn't able to do that. So like you said, maybe I'm a good rougher in a bad businessman, bad time management, you know. So sorry for anything that's caused it.
I did read through the report, so I'm familiar with all the information in that report. That includes information about your history and your background, Mr. Miller. And also, I presided over the trial. I heard all the evidence that was presented in this case. So I'm well familiar with the facts of what happened. certainly take all of that into consideration along with what you've had to say here today. I read through your written statement as well. Ms. Badgley, I appreciate you coming back again today, making a statement here on the record. It's never easy for people to have to admit that they've been a victim of a crime. It makes them feel like maybe, they did something wrong in some way. And it's certainly difficult to come up and talk about that in front of a room full of people. But I think it's really important that victims do come forward and make statements. Number one, I think hopefully it'll help you move on, the fact that you got to address this in an open court. But I also think it sets a good example for other victims to come forward and have the courage to do that. So I appreciate your statements as well. And it gives me a better insight into how this crime actually affected you in a real world kind of a way that doesn't come through necessarily on a piece of paper. So I take all of those things into consideration. I mean, Mr. Miller, you're 28 years old. You don't have any prior criminal history. I think that gives the court some reason to think that this could be an isolated incident, and that through probation, you can get back on the right track and not engage in this type of behavior anymore. So I think that certainly is a mitigating circumstance here. But the nature of the crime, the circumstances, I think is concerning. I don't think you have to have a higher education. I don't think you have to be a good businessman to know that you don't take $6,000 from somebody and not do the work and not give them the money back. I mean, I don't know what you thought the ultimate outcome was going to be. You had plenty of time to pay this back, to make this right. I mean, right up to the morning of trial. And if you had a bunch of money that you could have put towards paying Ms. Badgley back, maybe we could have avoided being where you're at right now at any point during that. So I don't know what you were thinking if you just thought you were going to keep that money and nothing else would ever happen. You didn't really have, and still don't have, any real good reason for either not doing the work or not paying her back in the amount of time that it's gone by. I don't think any of the excuses that you gave, frankly, are any reason to not have done that up to this point. I do think I got the real sense that through the trial and through your own statement that you wanted everybody to feel bad for you in some way. And clearly the real victim here is Ms. Badgley, who is struggling, who needs this repair done, who borrowed money to get it done, and she doesn't have the work done or the money. And she is certainly no better of a position to bear that burden than you are. So I really find that there's just absolutely no excuse for your actions in this case, your failure to make this right before now. And so I think that does call for a degree of punishment as well. So for all those reasons, I think the recommendation is well crafted here. It provides for a period of probation so that you're being monitored. It provides for some punishment so that you understand that this is absolutely not acceptable either as a businessman, but just as a person in the community taking money from somebody. It's just wrongful conduct, regardless of the circumstances. So it provides a degree of punishment for that and accountability for that. And I think that's very much appropriate in this case. So because we have a real victim who suffered a real loss, who continues to suffer a loss, I think that calls for, as a reason for the imposition of jail time. The court is going to follow the recommendation, sentence you to a period of probation for 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. The court is going to order that you serve 3 months in the Otsego County Jail. You do have credit for 14 days served. The court is going to order restitution in the amount of $6,750 that's payable to the Otsego County Clerk to be dispersed to Samantha Badgley. The court will order crime victims assessment of $130, a supervision fee while you're on probation of $30 per month, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost. You have the ability to seek an appeal of the sentence. Mr. Brown, if you could have Mr. Miller acknowledge the appellate rights.
Your Honor, he has signed that acknowledgement. I'm tendering that to the court.
Mr. Miller, you are remanded to the custody of the county at this time.
Bring it over.
I've got the sheets right here. People versus Kyle Lancaster, file number 256881.
For the record, time I called that.
Mr. Lancaster, if you come right to the podium there, please. All right, counsel, can you put your appearance on the record for me, please?
Good morning, Your Honor. Tanika Dick, P86794, standing in for James Dick.
All right, and are you appearing in the Lancaster matter?
Yes, Your Honor.
The record should reflect Mr. Lancaster is present here in the courtroom. We have this matter set for a status conference today. Ms. Dick, have you had an opportunity to speak with Mr. Lancaster about how we're going to proceed today with this file?
I think Mr. Dick has, he's said to me, so he's in, I'm sorry, he's another hearing in Otsego. He's in front of Judge Hessel, and he'll be there for a few more cases. He still has some things that he's trying to work out with his client, and he's hoping to get an adjournment for this, for today.
Okay. Mr. Rolla, do you have any objection to that?
I spoke to Mr. Dick last Friday, as a matter of fact, and I was aware he was going to do that. People don't have any objection, as the defendant did waive the preliminary examination, so we allow the plea offer that's currently in existence to remain open. I would, for housekeeping judge, I would ask that it's simply that the defendant waive this adjournment hearing on Mr. Dick's behalf for the purposes of this hearing.
All right, so Mr. Lancaster, have you had a chance to talk to your attorney, Mr. Dick, James?
Very briefly, it was only for like 2 minutes.
Okay, so what he's asking to do through the substitute counsel here today is have the court adjourn this hearing and reschedule this at a time when he can be here in person. And I think he also wants an opportunity to discuss the case further with you.
Yeah, he was saying something about meeting up at 2 o'clock today.
Yeah, so do you have any objection to that?
No, Your Honor.
Okay, do you have any questions about that?
No, Your Honor.
Okay. All right, so we're gonna set this for a hearing in about 2 weeks. And Ms. Dick, will Mr. Dick be in touch with Mr. Lancaster?
Yes, he will.
All right, so Mr. Lancaster, just make sure that you stay in touch with your attorney, and we'll proceed further at the next hearing. Do you have any questions about it?
No, Your Honor.
All right, thank you, that's all.
Thank you.
Thank you, Your Honor.
You can go ahead and disconnect, counsel, thank you. Is Mr. Kibbe present? Okay, Mr. Kibbe, if you come up to the front, please. We'll go on the record in People versus James. I'm sorry, Cody Kibbe. Right up to the podium.
Oh,
there.
sorry.
Kibbe's present here in the courtroom today. If I could have counsel put your appearances on. Kibbe. Mr. Brown, can you tell me the status of this file?
Yes, Your Honor, this is a relatively new case. This is my first appearance in circuit court. I have spoken with Mr. Rolla, and we are currently still in negotiation, so I am going to request that this matter be adjourned. I don't think more than 30 days would be necessary.
Mr. Rowland?
No objection, Judge. I've spoken to defense counsel and I of his request that was going to be made. So, thank you.
All right, and Mr. Rolla, has there been a plea offer in?
There is, Judge, and there's continuing negotiations depending on a number of matters.
Okay, all right, so we'll set this for a plea hearing status conference in about 30 days. So Mr. Kibbe, you need to make sure that you stay in touch with Mr. Brown, that you discuss any potential plea agreements with him. And when we're back at that next hearing, that you're ready to make a decision about whether you want to accept any of those agreements or go forward with trial, okay?
Sounds good.
Do you have any questions about that?
No, Your Honor, I don't.
Thank you, that's all for today.
Yeah, thank you too.
People versus Alex Doepfer, file number 256895 and 6896. Sir, if I can have you go right to the podium there, please.
For the record, John, I call that people.
Claire Brown, we have Mr. Gopher.
Record should reflect Mr. Doepfer is present here in the courtroom today. Mr. Brown, can you tell me the status of these two files here?
Your Honor, again, this is my first appearance in circuit court. There has been a plea offer made in the matter. I would like some more time to discuss that with Mr. Gopher. He also has some other cases going on, 3 files currently going on in the district court. They are misdemeanor files. So I would like a little more time to, again, speak with my client as well as possibly negotiate a little bit further with Mr. Roll.
Mr. Rolla?
It's a relatively new case, Judge. It's a situation where we have made a plea offer to defense that will involve some of his other files as well, but it hasn't been completely ironed out yet because proceedings are still even newer in the district court, as I understand it, than this matter was. We have no objection to a single jury.
All right, so the adjournment would be for the purpose of trying to arrive at some kind of global agreement that would resolve both the district court and these charges. Is
That would be the people's understanding. Yes, Judge.
Mine as well.
Mr. Doepfer, do you have any objection to the court allowing the attorneys a little more time to
No, sir.
to work this out and to discuss it with you?
Judge, it says the both files.
Right. Okay. All right. So we'll set this for a plea hearing status conference in about 30 days. As I told the previous gentleman, Mr. Doepfer, just make sure that you stay in touch with Mr. Brown so that when we're back at that next hearing, you're ready to make a decision about how you want to proceed. Okay.
Yes, sir.
Thank you.
Thank you.
Mr. Trush, are you ready with Mr. Banks' case?
Yeah.
Okay. All right, file the matter of People versus Banks. This is file number 256893.
Richard Trish, on behalf of Mr. Banks.
Good morning. Good morning. The record should reflect that Mr. Banks is present here in the courtroom today. Mr. Trush, can you tell me the status of this file?
Thank you, Your Honor. We're still in discussions with the prosecutor. I would say as recently as Friday, we were discussing a plea offer that contemplated either playing as a HAB 2 or a HAB 3, depending on the results of the lab. We had not had them yet. I did just receive them this morning at about 9:30. So I would propose to the court, I think there's one of 2 ways that we can proceed. Obviously, we could adjourn the matter, and I'm sure the prosecutor and I can complete our discussions on it. Or with the lab results coming in this morning, I don't know if the prosecutors had a chance to review them and is in a position to make a firm offer today.
All right, Mr. Rowland.
Mr. Trush, you have an advantage to me in this case. I haven't seen those results yet this morning.
Okay.
But There is a plea offer that, this is going to be resolved, I believe, by a plea judge, either today or at the very next hearing, as soon as I get a chance to see those results.
All right, if we were to set this for the full day in October in 2 weeks, would that be enough time?
I think that would be sufficient time.
I would agree, Judge.
Okay. All right, so given that those results have just been disclosed to the parties and haven't had an opportunity to review those, we'll set this for a plea hearing on the full motion day in October. And we'll go forward at that time.
And Your Honor, I would ask at the hearing, the next hearing, if Mr. Banks could be permitted to appear via Zoom. He's been admitted into a veterans treatment program in Battle Creek. It's a program specifically designed to deal with both substance abuse and PTSD. We anticipate that he will be at that program on that date.
All right, Mr. Rolla, do you have any objection to the Zoom appearance?
As long as the defendant agrees to sign the appropriate releases so that that information can be made available and his counsel can be available, as well as the defendant being available for the next hearing.
Okay.
No, Judge.
All right, so Mr. Banks, just make sure you communicate with Mr. True so that you have the appropriate technology and ability to connect with the court for that next hearing, okay?
Yes, sir, Your Honor.
And then, of course, stay in touch with Mr. Trush so that we're ready to proceed at that next date. And that's all for today. Mr. Frankel, we're a couple of minutes ahead of schedule, but are you ready with your case?
Yes, I am. Jason D. Crawford, Jr.
Yes, court will call People versus Crawford, this is file number 256844.
Record John, my phone back.
Defendant is in custody, Your Honor.
Yeah.
You did it properly.
Mr. Trush, I have Mr. McKenzie connected. If you want, we can take that case while we're waiting for Mr. Crawford.
Certainly.
All right, Mr. McKenzie, if you can unmute, please. There we go. Are you able to hear me okay?
Yes, sir.
All right, we'll go on the record in People versus Jamie McKenzie. This is file number 256877. The record should reflect that Mr. McKenzie is present by video by prior approval of the court. If I could have counsel put your appearances on this file.
The record John, my phone back. People.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. McKenzie, who is joining us via Zoom from the Lions Den.
And Mr. Trush, can you tell me the status of this file?
Yes, Your Honor. I believe we do have a resolution of this matter today, whereby Mr. McKenzie would admit count 1 and count 2, that being fleeing and eluding in the first degree and resisting and obstructing police officer. And those would be as habitual third offenders. The habitual fourth offender, as well as counts 3 through 6, all the misdemeanor counts would be dismissed. And contemplated in this was also a misdemeanor resolution of a couple matters in the district court. That was effectuated on Thursday.
Okay. All right, Mr. Roll, is that a correct statement of the plea offer?
It is, Judge, and perhaps for some clarification, one of those pleas is on the larceny with restitution. That's why it's being resolved in the district court as part of the.
Okay. All right, Mr. McKenzie, were you able to hear all of that?
Yes, sir.
And have you had an opportunity to talk to your attorney, Mr. Trush, about that plea agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. McKenzie, are you currently on any kind of probation or parole?
No, sir, I'm not.
Right. And under this plea agreement, you're going to be pleading guilty to fleeing and eluding third degree as a third habitual offender. That means the maximum possible penalty that you could face for that charge would be up to 10 years. Do you understand that?
Yes, sir, I do.
And then one count of resisting or obstructing a police officer as a third habitual offender. That means that the maximum possible penalty you could face for that charge would be up to 4 years. Do you understand that?
Yes, I do.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all those rights.
I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've talked about here on the record today?
No, sir.
Is it your own free choice to plead guilty to both of these crimes?
Yes, sir.
Are you pleading guilty to these crimes because you are actually guilty of each of these crimes?
Yes, sir.
The information I have indicates that this happened back on July 7th of 2025. Is that the correct date?
Yes, sir.
All right, and on that date, were you driving a motor vehicle here in Otsego County?
Yes, sir, on Camp 10.
Okay. And did you encounter a police officer at some point when you were driving on Camp 10 Road?
Yeah, I was coming off of Estelle on the C-42 and then on the Camp 10. And as soon as I pulled on to Camp 10, the county sheriff pulled me over.
Okay. Did that officer activate his lights or his siren or give you some indication that they wanted you to pull over?
Yes, sir.
Right. And did you fail to do that at least at first?
No, I initially did pull over and gave my license and whatnot, and then I didn't have any proof of insurance at the moment in time because I just bought the truck. And then when he came back, he tried to remove me out of the vehicle, and my door was locked. And it was only after that I ended up. It's kind of more complicated, but I initially did stop, yes, and then after he tried to take me out of the truck and everything like that, that's when I left.
Okay. So he gave you some commands to get out of your vehicle?
Yeah, yes, sir.
Okay. And rather than doing that, you drove away from that from the scene there?
Yes, sir.
Okay. And I know I already talked about having the lights on the police car, but did you know that was an officer, a deputy?
Yes, sir, I did.
Okay. Had you previously been convicted of receiving and concealing stolen property in 2024?
I don't remember that. To be truth be told, receiving sandstorm probably 24. I know that I had.
Mr. McKenzie, it indicates it was a motor vehicle in 2024.
Oh, yeah, that Mustang. Yeah, no, that was a whole messed up situation downstate in Van Buren County. Like whenever they picked me up on it, because I purchased the vehicle and come to find out it was stolen, and I was actually suffering from a concussion at the time, and I woke up in the car with, I think it was Allegan City Police taking me out of the vehicle. Like somehow I ended up in the hospital parking lot and I was unconscious, but with the vehicle running in gear, windows down, and it was nighttime. And I guess somebody from the hospital came out to try to wake me up, and I was unresponsive, so they called the Allegan City Police, and then I got arrested from that. So yes, I do remember that now. Yes, sorry.
Okay. That was Mr. Trish, why don't you go? You got,
Okay,
you
so
might have better.
so that was in 2024,
Yes, yes.
and then in 2019, were you convicted of furnishing contraband to a prisoner?
Oh yeah, that was while I was still incarcerated. Yes.
I think that should stand.
Mr. Roller, are the people satisfied with the factual basis?
Yes, Judge, thank you.
Mr. Trush?
I'm satisfied.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, thank you.
Mr. Trush?
I'm aware of none.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Mr. Trush?
Defense is satisfied.
Mr. McKenzie, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. That hearing will be in person here in Otsego County. So you'll need to make arrangements to get here from where you're at currently, okay?
What was the date again? I'm sorry, I was trying to write it down.
I'm gonna have to, the court will give you a written notice of that date. I'm not sure what it'll be sitting here today. But once it's scheduled, you'll be provided notice of that along with your attorney, Mr. Trush, and you'll have an opportunity to talk to him prior to that hearing. And then somebody from our probation department will also be in touch with you to do a pre-sentence report, okay?
Yes, sir.
Jamie, if you haven't got anything in the mail in the next 2 weeks, call my office, okay?
Yes, sir. Will.
Okay, thank you. That's all for today. And we're gonna go ahead and disconnect, Mr. McKenzie.
All right, have a good day.
Right. Sir, are you Mr. Crawford there at the jail?
Yes, Your Honor.
Okay, we'll go on the record again in People versus Jason Crawford. The record should reflect Mr. Crawford is now present by video from Otsego County Jail. This is the final status conference and plea cutoff. In this case, we have trial set to begin on September 29th. Mr. Fragel, have you had an opportunity to go through any current plea offers with your client?
I have, Your Honor.
And how does he want to proceed?
We'd like to plead guilty to counts 2 and 3, CSC second degree, person under 13 years old. And count 1 would be dismissed.
Mr. Rolla, is that a correct statement of the plea offer?
That's correct, Judge.
Mr. Crawford, have you had an adequate opportunity to talk to your attorney about this plea agreement?
Yes, I have, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Crawford, are you currently on any kind of probation or parole?
I am not, Your Honor.
All right. And you understand that the maximum possible penalty that you can face for each of these charges, which is criminal sexual conduct in the second degree, each of them carry a maximum possible penalty of up to 15 years in prison. Do you understand that?
Yes, Your Honor.
And that by law, conviction for those offenses requires lifetime electronic monitoring once you are released from any kind of incarceration. Do you understand that?
Yes, Your Honor.
With all of those things in mind, what is your plea to each of those charges here today?
Your Honor, I plead guilty to both of those.
All right, I'm going to go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all of those rights?
Yes, Your Honor.
And you understand that by pleading guilty, you're going to be giving up and waiving all of those rights, and you won't have them anymore, and that includes the right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've talked about here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of each of these crimes?
Yes, Your Honor.
All right, Mr. Fragel, the information doesn't really contain much factual information for me to go on. Can you question your client to establish facts?
Certainly, Your Honor. I believe we'd like to amend the information to the on or about date. It should be April of 2016, as opposed to January 1st of 2018.
Mr. Rolla?
We have no objection to that, rather, for the purpose of the plea, correct?
Okay. So we'll note that for the record, and Mr. Rolla, will your office prepare an amended?
I've already done, made a note of that, effect. Thank you, Judge.
Thank you. Mr. Fragel?
Mr. Crawford, were you in Otsego County during the month of April 2016?
Yes, I was, Your Honor.
And during that time, you were alone at a residence in Otsego County with a person under 13 years old, correct?
Yes, Your Honor.
That person was a female?
Yes, Your Honor.
And while you were alone with her, did you make sexual contact with her?
Yes, I did, Your Honor.
You can call me Mr. Fragel. However, the sexual contact as to count 2, describe that to the court, what sexual contact you made for count 2.
I pulled out my penis and I showed her it and she touched it. And I also touched her buttock and the inner thigh by her genital area.
Okay, so for count 2, she touched your bare penis, is that correct?
Yes, sir.
Was that done for a sexual purpose?
Yes, it was.
And for count 3, you touched her inner thigh and her buttocks, is that correct?
Yes.
And that was done for a sexual purpose?
Yes, sir.
And both of those incidents, Mr. Crawford, they occurred here within Otsego County?
Yes, Your Honor.
Okay. All right, Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Fragel, are you satisfied with the factual basis?
Yes, Your Honor.
Okay. Mr. Rolla, are the people aware of any threats, promises, or inducements of what's been placed on the record?
None by the people, thank you.
Mr. Fragel?
No, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking?
Yes, Judge.
Mr. Fragel?
Yes, Your Honor.
Thank you. Mr. Crawford, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of the charges in this case. Court will accept the guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, somebody from the probation department will be in touch with you to complete a pre-sentence report. And you'll have an opportunity to go through that with Mr. Fragel prior to the sentencing hearing. Anything else?
Just that the court's taking the child matter off the docket.
The court, yeah, in light of the plea, the court will adjourn the jury trial currently scheduled for September 29th. Mr. Fragel, anything else we need to address?
No, thank you.
All right, thank you, Mr. Crawford. That's all for today. The court's going to disconnect at this time.
You, Your Honor.
Mr. Blumberg, were you ready with Ms. Willie's case?
We are.
Okay. Court will call People versus Willie. This is file number 256879. Wonder if I can have your client come up to the podium there, please. The record should reflect Ms. Willie's present here in the courtroom today. If I can have counsel put your hands on.
Morning, Your Honor. Elliot Lumber, as the defendant, standing next to me.
Thank you. This is set for a status conference today. Mr. Blumberg, can you tell me the status of this file?
Sure, Judge. This is our first appearance in circuit court on this matter. While we've had some initial discussions with the prosecutor's office, we have not yet come to a resolution. I'm hoping that we can do that. There is another matter pending in Antrim County with the same allegations. So we're hoping to resolve all the cases at one time if possible.
What, in terms of the time frame for the next hearing?
I think if the court gave us 45 days, we should be able to come to a resolution.
Mr. Rolla, do you have any objection to that?
I would agree with what Mr. Bloomberg's indicated on the record. We have no objection to the 45-day jury.
Okay, so we'll set this for a plea hearing and status conference. I will set it for the court's full motion day in November. So that'll give us about 45 days. So Ms. Willie, it's just important between now and then that you stay in touch with Mr. Blumberg so that you're ready with a decision about how you want to proceed at that time, okay?
Second.
Mr. Roll, is there anything else that we need to address today?
Not in this matter. Thank you.
Mr. Blumberg?
No, Judge, thanks very much.
Thank you.
Thanks, sir.
People versus Seguin, file number 256845. Podium there, thank you. Mr. Trush. See on this file today.
Thank you, Your Honor. I am happy to report, I believe we do have a resolution. This was set on sort of a short notice. I think we were here at the beginning of the month. Asked it to be set out about 2 weeks so we could get the answer from the sobriety court. They have accepted Mr. Seguin into the sobriety court, and we are prepared to enter into an agreement today. That agreement would contemplate him pleading as charged to the OWI third offense. And if he successfully completes a drug court program, it would be reduced down to a OWI second offense of 1 year misdemeanor.
Okay, Mr. Roll, is that a correct statement?
That's accurate, Judge. No, I apologize for the delay, but we had to wait for a decision from the other court before we could finalize this agreement for the record.
Okay. All right, Mr. Seguin, have you had an opportunity to discuss this with Mr. Trush?
Mr. Church.
Trush.
Oh, true. Yeah,
Sorry.
Yes, that's okay.
Oh, and
Yes, I have.
just for the record, there is a $230 reimbursement to the Gaylord City PD pursuant to statute,
Okay.
and that is part and parcel of the agreement.
Thank you. I do want the record to reflect Mr. Hamlin from the sobriety court program or drug court program is present by video. Mr. Hamlin, we're going forward with a plea for Mr. Seguin today, condition on his participation in the program. Is there anything that you wanted or needed to add to that?
No, Your Honor, I just want to be present for the hearing with respect to the court because I'm not all too familiar with this case and I'm trying to get caught up.
Okay. All right. Mr. Seguin, if you can raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. So Mr. Hamlin, just so that you're aware, because I don't know if you were connected when this was stated for the record, but Mr. Seguin's going to be entering a plea to operating while intoxicated as a third offense. And the offer is in exchange for that plea, if he successfully completes the sobriety or drug court program, that would be reduced to a second offense.
Thank you.
So Mr. Seguin, as a third offense, the maximum possible penalty you could face would be up to 5 years and or a $5,000 fine. Do you understand that?
Yes, Your Honor.
Okay. And that's if you were to unsuccessfully, be discharged in some way from that program, then you could be subject to the maximum penalty as the third offense. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty?
Yes.
The date I have for this incident is back on September 26th of 2024, so almost a year ago. Is that the correct time frame?
Yes.
On that date, had you been consuming?
Your Honor, if I
Is this
could.
yeah. Okay.
So you were here in Otsego County on September 26th of last year.
Yes.
You were operating a silver Pontiac G6 on that date,
Yes.
and you were operating that on North Center Avenue.
Yes.
And on that date, had you consumed some lorazepam?
No.
Okay. When did you consume it?
The night before I went to bed.
And when you were operating the vehicle, did you have a blood test taken?
Yes.
Or subsequent to that?
Afterward, yes.
And did that show the presence of lorazepam in your system?
Yes.
Did it also show the presence of THC in your system?
Yes.
And did that lab show 30 nanograms of lorazepam?
I'm just gonna say yes, but I don't know what the actual.
Judge, I believe the parties stipulate to the lab results. in that regard.
Mr. Church.
We would stipulate there were 30 nanograms of lorazepam and 5.6 nanograms of delta-9 carboxy THC.
Correct, Your Honor.
Thank you.
And would you agree that that affected your ability to operate the motor vehicle on that date?
Yes.
Okay. Did it affect your ability to normally and safely operate that vehicle?
Yes.
With that, Mr. Rolla, do you?
With that clarification, the people are satisfied, as long as the court may go through his prior convictions.
Mr. Truish, can you do that as well?
Yes, and you were previously convicted of an operating while intoxicated offense on in July 14th of 2022.
Yes.
And then again, a similar offense in November 14th of 2024.
Oh, that was in September as well.
You agree that you have at least 2 prior convictions?
Yes. Yes.
Thank you. Mr. Roller, are you satisfied with that?
People are not satisfied. Thank you, Your Honor.
Mr. Roller, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
We are not.
Mr. Church.
Aware of none.
And Mr. Roller, are the people satisfied that the court has complied with statute and court rule in taking this?
Yes, Judge.
Mr. Church.
I'm satisfied.
Thank you. Mr. Seguin, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important, number one, that you stay in touch with Mr. Trush, that you maintain contact with and respond to any requests from the drug court program. And that somebody from the probation department will be in touch with you for the pre-sentence report, and that you follow up with that as well, okay?
Yes, sure.
Mr. Church, is there anything else we need to address today?
I don't believe so, Your Honor.
Mr. Rolla?
Your Honor, thank you.
Mr. Hamlin, is there anything that you need Mr. Seguin to do for purposes of today's hearing?
No, Your Honor, thank you.
Okay, all right, thank you. That concludes this hearing. Our next hearing is set for 10:45, so we'll take a short recess.
All rise.
Looks like we've got everybody connected, so we'll go on the record in Petit versus Petit. This is file number 2520096. If I could have both counsel put your appearances on.
Good morning, Your Honor. Jennifer Dusman-Coy on behalf of Jessica Petit, who is present with me in my office.
And Zach Backlund, Your Honor, on behalf of the defendant Monty Petit Jr., who's also appearing remotely by Zoom.
Thank you. We're on the record today for status conference. Just looking at the file prior to the hearing today, it looks like the parties did participate in mediation maybe about a month ago, maybe a little less than that, that there was at least some partial agreements made. So I just would like to see from counsel where you'd like to go in terms of scheduling. Ms. Dukes-McCoy on behalf of plaintiff.
Well, Your Honor, I think I would ask for discovery to extend another 30 days. We got a discovery request from the defendant that we haven't completed yet. So, but after that, I think maybe we would ask for another status conference or even a settlement conference. These parties, I don't think are going to be able to return to mediation and do more of that. But I think we're getting to the point where counsel and I are trying to negotiate, but we're not making much progress. And I know both parties want to get moving on this. So I don't want to extend things for very much longer if we're not going to be able to make agreements.
Okay, Mr. Backlund.
I think that's consistent, Your Honor. A settlement conference might be a good idea if we were able to attend that possibly in person, if you were to be available for consult during that process. Otherwise, I agree with getting things moving so that these parties can see the light at the end of the tunnel for when this might be resolved.
All right, well, I think maybe what we should do today is get a final bench trial date, timeline for that. And then we could kind of work back from there. So if we were to try this, Ms. Dukes-McCoy, if we set this at 60 to 90 days out, I mean, is that enough time for you to be ready to proceed to a bench trial?
Yes, Your Honor.
Mr. Backlund?
Agreed, yep.
Okay. And Ms. Dukes-McCoy, how much time do you think we would need for that evidentiary hearing?
Oh, I would say a day for both parties' proofs.
A day each or a day total?
I think a day total.
Okay, Mr. Backlund?
Yeah, I think that's accurate, Your Honor. There are issues, there are no minor children in this matter, but there are issues of perhaps separate versus marital property that'll take proofs from both parties along with the value of assets and certainly the division thereof. So I think a day would be appropriate.
Okay. So we'll set it for a one-day bench trial at 60 to 90 days out. I will set it for a settlement conference on a date, 14 to 30 days prior to the trial date. I will set that for a 2-hour settlement conference. I'm going to request that counsel, whenever we get that date, that 7 days prior to that date, that counsel just submit to me, something in the nature of, maybe even a trial brief or some kind of mediation brief, something that where I can look at and understand what the issues are between the parties prior to that settlement conference so that I can, meaningfully participate in that and try to help facilitate something. And then, if we're not able to settle it and we end up going to the bench trial, then I wouldn't need you both to repeat that and, file a trial brief ahead as I normally would do anyway. So that'll give me a much better understanding, I think, of where the parties are at, so that we're all able to participate in that settlement conference in a meaningful way. So I'm going to put in the status conference order that the parties to submit a brief 7 days prior to the settlement conference. And that'll give us a framework. I'll just order that discoveries to remain open for now. That'll give us a framework for going forward, and that'll give us a final date to get this resolved if the parties aren't able to agree prior to that. Ms. Dukes-McCoy, do you have any objection to any of those dates that I've just discussed?
No, Your Honor, I did have a question. Would there be a cutoff date for any motions to be filed, whether those are motions that relate to the issues between the parties, or if there's a motion, that kind of thing?
Yeah, I certainly would, I wouldn't want those issues to be raised, on the morning of trial if we get that far. So I guess, unless either of you object, we could make the settlement conference date the cutoff for having any motions filed or heard. That way, if there are any legal issues, we'd be coming to that settlement conference with those either already decided or set to be decided on that same day.
Okay,
Mr. Backlund, do you have any objection to that?
No, I think that timeline makes sense, Your Honor.
All right, so just to recap, I'm going to put into the scheduling order that we're going to set this for a 1-day bench trial at about 60 to 90 days out. We'll set it for a 2-hour settlement conference, 14 to 30 days prior to the trial date. Parties to submit briefs 7 days prior to the settlement conference, and any motions to be filed and set for hearing no later than the date of the settlement conference.
Okay.
Ms. Deuce McCoy, on behalf of plaintiff, anything else we can address for your side today?
Not for today, Your Honor.
Mr. Backlund?
No, we've covered it, Your Honor. Thank you.
Okay, so I'll send out the status conference order reflecting what we've discussed, and then we'll also send out notices for the settlement conference and bench trial dates. And all parties are free to disconnect on this file. Thank you.
Thank you, Your Honor.
And our next hearing's at 11, so we'll be ready to go on the record at that time. I'll take a short recess until. Okay, we'll go on the record in Peyton Jones versus Munson et al. This is file number 2519251. If I could have counsel put your appearances on, please.
Good morning, Your Honor. Rebecca Walsh and Jenny Sikorsky on behalf of the plaintiffs.
Good morning, Your Honor. Ralph Valentini appearing on behalf of Doctors Minor, Kiley, and Murphy.
Good morning, Your Honor. Jenna White Freeman appearing on behalf of Munson. Let's see, good morning.
Okay, good morning. Got a lot to go over here today in the next few minutes. So I want to thank you all for being here in person. I think sometimes it's easier. It's nice to see everybody in person. I don't know if we've had any hearings here in the courtroom.
Not yet.
All video for a couple of years. So I guess the first thing that the whole purpose of today, in my view, is to talk about trial, talk about issues that we may need to address and get some things just squared away so that when we get to the morning of trial, we can start right up with jury selection and go right into opening some proofs as quickly as we can. So I guess my first question, and I'll direct this first to plaintiffs. I mean, are we going to have a trial? Is this something that's fairly certain? Are there still negotiations ongoing? I just want to get a sense for, as we gear up for this, whether or not this is going to be a last minute settlement kind of a situation.
I'm not sure. Do you want me to stand or do you want to?
I think we can be kind of informal with this.
Okay. Thank you.
More or less a on the record discussion about how we're going to go.
So I would say we are still negotiating. And I think to get into more details, probably be better to talk just to the plaintiffs and then the defendants about that if you'd like, but I'm happy to update you on that if you like.
Yeah, I mean, I'll hear from everybody where you all feel that you're at, because it may not be the same. So.
Yes, I agree, but we are still negotiating. So I think we're preparing to, at least our side is preparing, moving forward toward trial, but also keeping the door open and having discussions about negotiating a settlement at the same time.
Okay, all right. Mr. Valentini or Ms. Freeman?
Well, I believe that there are, let's put it this way, negotiations have not finished. And the defendants have not made their final offer. I can say that, I think.
Okay.
And I echo that as well.
Okay. All right, well, let's just go forward with today then. I appreciate all those comments. That helps me, I think, kind of gauge a little bit better at where we're at. So the first issue I wanted to address, there's been numerous motions limine that were filed, which number one, I appreciate counsel doing that and complying with the court's cutoff dates. I counted a total of 20 motions, I think 13 on the defendant's side and 7 on plaintiff's side. I've had a chance to review those, not in depth, and I don't intend on proceeding with oral argument on those all today. But from what I've reviewed and in my view, and of course, I'll give both sides an opportunity to be heard on this, but at this point, it's my intention under MCR 2.119E3 to exercise my discretion to dispense with oral argument on those motions and decide them in writing, which I will provide to all of you 21 days prior to the trial date. Because that is something that I'm notifying you of or making a decision on here today, and both sides may have anticipated having oral argument on those motions. I'll give each side 14 days to supplement anything that you'd like to, that you feel that may have come out or that you would have stated in oral argument that's not already in your briefs. Once I've received those updates, then again, the court will issue written rulings as to each individual motion and provide that to the parties again well in advance of the trial date. Anything the plaintiffs would like to say for the record on that issue?
I have nothing to say, Your Honor, and quite frankly, I think most of them could easily be decided by the court without hearing. So
yeah,
I actually support. I'm in favor of them.
Okay, Mr. Valentini.
Well, I think oral argument in some cases lends more heat than light, and I think trusting Your Honor to read and decide the case based on the written material is a good idea.
Okay, all right, thank you, Ms. Greenman.
I agree.
All right, so that's how we'll proceed with that. And by the way, I'm gonna do a status conference order coming out of what we discussed today, so I'll put all of this in writing for you as well, to the extent that there are timelines and things discussed. Okay, so the next thing, I'm just gonna go through my list of things that I normally address at this trial prep conference, and then I'll open it up if there's further things that the rest of you would like to address. First of all, with regard to the jury, how many jurors do you guys want to have impaneled? I mean, I've had these kind of cases and it's varied, so I always like to inquire of counsel, as you're all aware. I mean, we can impanel 7 or more. We can agree to have all the jurors deliberate. We can agree to excuse alternates and narrow it down to a jury of 6. We obviously we can have, or we need to decide how many jurors are going to compose a verdict. Counsel, what's plaintiff's view on that?
My preference would either be to seat 7 or 8, have them all deliberate, and then a verdict would be 5 out of 7 or 6 out of 8.
Mr. Valentucci?
I'd agree to seat 8 and a jury of 6 out of 8.
Okay, Ms. Green?
That's always my preference too.
That sound okay?
We're together. We don't have we represent all the same people. So
Yeah,
I'm speaking to both of us.
I know. I know you mentioned that as one of the options, but
Yeah, oh yeah, oh, absolutely.
So we're good with seating 8. They will all deliberate, and 6 will compose the verdict. Okay. Peremptories, each side gets 3. If we have adverse interests, I mean, defendants have the opportunity, I think, and we need to discuss that as to whether or not you would each get 3, and then the plaintiffs would get 6, or whether the defendants would be combined for 3. I mean, I don't know how much and to what extent either of you are going to be pointing the finger at the other in terms of, for purposes of deciding how many peremptories. So, Mr. Valentucci, what's your view on that?
Well, the defendants will be requesting separate interrogatories to the jury because of the coverages. And though the hospital defendant is vicariously liable for some of the defendants, not all. The plaintiff's allegations in the case, as they have involve or may involve a subcontractor of defendant hospital, and therefore we would be requesting separate peremptory challenges. Though there are no cross claims between the defendant and the hospital, there are separate issues that merit separate consideration by the jury. And certainly a jury verdict wouldn't be inconsistent as to one defendant without the other being found negligent. So we would ask for 6, 3 for the doctors separately and 3 for the hospital.
Ms. Green?
Yeah, I would agree with Mr. Valentucci. There, I don't believe there's any finger pointing, but because there are some separate issues that have been fleshed out throughout the pendency of discovery, that would be my preference that I would lean toward.
Okay. Ms. Walsh or Ms. Korsky, what's your view on that?
As long as we get 6, if they get 6, and we get 3, if they get 3, that's our only request.
Okay. All right. I think it's fair. I think in the exercise of the court's discretion, I think allowing each defendant 3 peremptories under these circumstances, I'd rather be more cautious about that than less. So each defendant's attorney will get 3 peremptories, and then plaintiffs will get 6. Okay.
When you say each defendant, you mean each group of defendants?
Right, so under the court rule, it's not each individual defendant, it would be each attorney representing the groups of defendants, so. I would anticipate 3 and 3 on the defense side and 6 for you.
That's all. Thank you.
Okay, in terms of final jury instructions, I usually request, I'm sorry, that each side submit in Word format so that I can edit them. Your sets of proposed jury instructions. Mrs. Korsky or Ms. Walsh, any objection to that?
No, but would you like us to work with them and try to get one combined set and then just submit separate ones if we have disagreements about them?
Yeah, I mean, that would be great. Usually I just get both sets and then I compare them and see which ones are different, and then we'll address those on the record. But if I am going to, as we get through my list here, I am going to require that you meet to discuss any potential joint exhibits or any potential stipulated exhibits. So let's just add jury instructions in verdict form to that list. And then what I'll say is, if you can, I'll just ask that each side submit any jury instructions that are agreed to. And then the ones that aren't agreed to, if you can each submit your own versions of the ones that are not agreed to. So. And same with the verdict form as well. All right, and then same thing with regard to exhibits and witnesses. I'm going to require the parties to meet at least 7 days prior to the trial and attempt to agree on any joint exhibits or stipulated exhibits. To the extent that the exhibits are stipulated, they can just be, admitted at the time of trial. To the extent that we're going to have any joint exhibits, I would like them marked separately as joint, as opposed to just stipulated exhibits, which are either plaintiffs or defendants with no objection. And then same thing with the witness list. What I'd like to get and have the parties exchange 7 days prior to the trial is final witness lists. In other words, the witnesses that you actually intend to call, not the the broad list that we also exchange. I want to be able to have an idea of how many witnesses each side is going to actually call at trial. And again, I'll ask you to exchange those and submit them to the court 7 days prior to the trial. So Ms. Walsh or Ms. Sikorsky, as to any of those issues involving instructions, exhibits, and witnesses, anything else that you want to add to that, or any concerns that you have about what we discussed?
Nothing, I don't know.
Mr. Valentini?
No, I agree with the court with regard to the instructions, and hopefully we can agree on the same. And I would ask the court to exercise discretion under 2.512 D4, 2.512 D4, to select instructions that the jury may have after they're sworn, but before the proofs before the evidence begins, so that they have a way to organize the evidence as it comes in relation to its relevance, and they're not lost at sea as to what is relevant and what is not relevant.
Okay. So I guess to that extent, if there are non-standard civil instructions, I would like to see if you guys can agree on what those would be, and if you can't, to submit them to me. Ms. Greenman, as to witnesses, exhibits, and instructions.
Yeah, no objection. I'm fine with what you proposed, working with plaintiff's counsel.
Okay. The next thing I have is just technology here in the courtroom.
I'm sorry, can I just ask you a question?
Absolutely.
Can I just address the request of Mr. Velatuti?
Mhm.
Because I would ask that you not do that, because some instructions are going to be, we may use them and we may not use them, and to give them an incomplete set of instructions at the outset would could be misleading to them. It could lead them down the wrong path, so I'd rather them get all the instructions at once. And there will be instructions that will be dependent upon what testimony comes in, whether they're given or not. So I would ask that you refrain from exercising any discretion to give them the jury instructions at the outset, because then, I mean, I wouldn't want to have to say, okay, you heard this one, but now you have to unhear it, or you didn't get these three, but now you're going to get them at the end after all the evidence has come in, and that could, you know, their whole view of how the case is, instead of deciding it all at the end, they might decide it earlier on, and then an instruction that we need at the end might not weigh as heavily with them.
Okay. All right. I guess what I'd like to see, Mr. Velatuti, is what you would be proposing the court to read
Yeah.
to the jury.
And I cited the wrong rule, I'm sorry.
Okay.
It's 2.513 parent E, I'm sorry.
Okay.
2.513 parent E gives the court authority to give to the jury. And what I would propose is the core standard jury instructions that it would be error not to give, which are the standard malpractice jury instructions. And that's under E, giving the jury a reference documents, which includes relevant statutory provisions, which malpractice instructions contain the statutory changes to the law. And those are standard instructions, they won't change. And with regard to the later instructions, of course, they would be in the final jury instructions, but it gives the jury a rough framework. I find that jurors are much more appreciative of having the nature, breadth, and extent of the controversy explained to them right at the beginning. And then they understand their role better than having everything come in just before they go out and have to go over the instructions and think about them, sometimes hours.
Mm-hmm. Squelch. I mean, what I'm reading that rule, and I have had, particularly in lengthy medical malpractice cases where the parties have stipulated to a booklet, which includes, you know, information that both sides want the jury to have as they go throughout the trial. And counsel, they get together, they produce, in this case, would be eight binders that are presented to the jury, which include things like stipulations that parties have agreed to, elements that the parties agree are going to be applicable to the claim, jury instructions that are going to be applicable. To the extent there are joint exhibits, they've been included in those binders. But that's something that's, I've never ruled on that. That's something that either the parties have agreed to do or not agreed to do. And so Ms. Walsh, you may want some time to think about that.
Yeah, definitely. I think we'd want to brief it and go back and, I mean, this is the first time I'm hearing about it, and I've never done that before. I've never had a jury that got confused or didn't understand. I think if we all do our job by the end of opening statement, they understand what the issues are they're looking for. So I don't think it's necessary. That's my off the top of the head, but I'd be happy to think about it and submit a brief to the court on our position on that within 14 days with the other things, if you'd like, Your Honor.
Okay. Yeah. Do you have any objection to that, Mrs.
No.
Freeman or Mr. Bell? I really think, I mean, before you guys start filing briefs, just have a discussion about it, because and I understand your hesitancy just off the cuff here. I wouldn't want to agree to anything necessarily that I haven't done before in a trial either, just sitting here. But I can tell you that in the cases where that's done, and I talk to juries after trials in criminal and civil cases, and just to let you guys know, I send out like survey forms that allows the jurors after the trial to give feedback both to me in terms of how the court did things and their service, but also to the attorneys about what was helpful, not helpful, and then I provide that feedback to the lawyers. Sometimes we get a lot of feedback, sometimes one or two jurors provide the feedback. It's always different, but I think it's helpful, and I always provide it to attorneys because I think the jurors have to say as well. And I can tell you in the trials where we have done those booklets, they have given positive comments about having information that they can refer to, particularly in the longer, week to 2 week trials with a lot of expert testimony. There's a lot thrown at lay people. But I've also had cases where the parties couldn't agree, we didn't do it, and the jury's got along fine as well. So something to think about. And but I agree with your timeline, Ms. Walsh. I think that's fair. Mr. Valatutti, if you really want to push for that, each side, and there isn't an agreement that each side can submit in 14 days, and I'll make a decision with enough time that those can be put together and not be a last minute. Anything else, Mrs. Walsh, on that issue?
Not on that issue. Thank you.
All right, so moving on then to my next topic, which is again our courtroom technology. We have very limited courtroom technology here. The screen is available. You can plug a computer into that. I found that it's, especially for detailed presentation of evidence, that is usually inadequate for these kind of cases. They're fine in criminal cases when all you're doing is putting up elements of a crime for a jury to see, or playing a 5-minute clip of body cam footage or something like that. But to the extent you're going to be playing depositions and those types of things, or have need for real technology, I would suggest bringing your own. We're always available through the clerk's office. If you contact the clerk's office, if you want to come the week before and test out all your stuff and get a better view of the layout of the courtroom and all of that, you're more than welcome to make those arrangements and come in and access the courtroom so that everything that you're going to bring is going to work, and you have a place to plug it in, and where you might want to set it up so that the jury can view it. I can tell you in the fall and winter, we get a lot of sun coming through here, so the jurors are looking at windows when we put the shades on, but that can be a challenge sometimes. And there's just not a lot of room in the well here. So Ms. Walsh or Mr. Korsky, can you give me an idea of what you might be bringing in terms of, or how you're going to be doing your presentation of your evidence from a technical standpoint?
Yeah, I don't anticipate using a lot of technology. I'm so old school. But I did have one question about technology, and that was if I have one expert that I was hoping could appear by Zoom. He's working on his schedule, but it would help. I think it would, if one expert could appear by Zoom, I would request that we be allowed to do that.
Okay, Mr. Valatutti or Ms. Greenman?
I don't object.
Okay, Zoom does work pretty well. I have very few issues with connectivity and that kind of thing, and I use it very frequently every day. So I don't think that'll be a problem. All you'll need to get from my office is just my PMR for my Zoom, so that they know how to connect in. That would be fine. Okay, Mr. Valatutti, how about your side in terms of, or Ms. Greenman?
Yeah, if I may.
Yeah. I'm just going in order down the line.
Absolutely.
I'm not meaning to put you last.
And I'm not more tech savvy by any means. I just, have a question for my last trial. First, do you know if to connect to the screen, if it's just HDMI cable?
Yeah.
Yes, okay. Second question, I often use trial tech simply because I'm not savvy enough to be able to, throw up medical records or something of that nature. Usually he just sits at a little table. I noticed this table here, but I'm not sure if that's used once the jury is selected. Is that appropriate?
Yes.
To have somebody just pop from their computer or hook up to HDMI if necessary?
Yeah, I mean, to the extent that anybody has a tech person that they want to bring, I think that's great, because
I'm all
definitely
functional,
not, and
so,
we
yeah.
aren't. So if you have somebody who knows how to make things work if they go awry, that would be awesome.
Okay, thank you.
Okay, Mr. Valatutti, how about, and just from defense side, are you both gonna have deposition testimony that's gonna be played for the jury, or are we gonna have all live with the exception of the Zoom?
Right now, we anticipate live witnesses.
Okay,
It seemed like the last time I was here, there was a rollout from the back there that the jurors could see closer. You don't have that?
like a TV, you mean?
Oh, maybe the TV.
That's always been in that
That's it?
location. Yeah.
There's nothing in the back room.
No, all we have is this chalkboard, which I can't believe we still have a chalkboard in here. I think just
Actually,
nobody's taking the time to get rid of it.
Yeah.
But I don't,
Yeah.
I've been on the bench for 13 years. I don't know that chalkboard's ever been used. but-
Okay, well, then I'm gonna leave that aspect of my co-counsel.
Okay. And again, you know, if anything changes, I would encourage both sides to talk to the clerk's office, make arrangements to come in if you need to ahead of time, just so that we aren't spending any downtime with jurors waiting, working on IT issues. So then the last thing I have is just kind of the daily schedule that I typically follow. You know, we'll start right with jury selection on the morning of the 23rd, which is a Thursday. Once we have the jury selected, we'll just go right into opening. So I don't spend one day just on the jury and then come back. Hopefully we'll be able to get a jury picked Thursday and still have time left over to start the case. So we'll just go right from jury selection right into the case. Typically we'll start, you know, around 9 a.m. every morning. Go until sometime between 4 and 5, depending on where there's a good natural break in witness testimony. I try not to keep the jurors beyond 5 o'clock, except for deliberations if we need to. And I give them plenty of warning about that. Usually a mid-morning break for 10 or 15 minutes, a mid-afternoon break for 10 or 15 minutes. I try to give the jurors an hour and 15 minutes for lunch. So those are the kind of breaks that we'll take, but generally, you know, a 9 o'clock to 4:30, 5 o'clock trial day, full day each day. I think there's anything else in terms of schedule, Ms. Walsh? Yes.
I do have one question. I would ask that if we could agree that, well, what I would like to do is not have to call my first witness until the morning of the 24th. So do jury selection opening. I understand that we might not get through that, but if not, that means my expert I have to pay him to come a whole day earlier to sit here all day Thursday, just in case there's a little time. And it would be much more, we will be very efficient on our side. And we will, I mean, and I would prefer to start Friday morning if we could.
Do you have any foundational witnesses that you could call on Thursday afternoon?
Well, I sure hope not. I hope that they will agree with us to stipulate to all the records custodians, which I have not asked yet, so that's my bad. But if they do, I would not anticipate that.
All right, well, my preference is, of course, I hate, especially in a 7-day trial, to let jurors go at 3 o'clock on the first day. You know, I would prefer that you had, and I totally understand about the expert, I would prefer that if you had a witness or witnesses that could be called on Thursday, that you do that rather than sending jurors home without, with time in the day still left. If you can't do it, you can't do it. You know, issues come up during trial, I understand. I expect both sides to do their best to schedule their witnesses so that I don't have jurors not using their time. So that's my preference. I'm not going to force you to call somebody you don't want to call and prejudice your case.
Okay.
I'm not going to do that.
As the trial prep goes, there might be an hour or two of something that we could fit in there. I mean, we will keep that in mind. I just wanted your permission to not have to have the first expert here until Friday morning.
Yeah. Yeah, I mean, that's fine. Okay. But my preference is if your first expert isn't going to be here till Friday morning, that you have some witness that we could call Thursday if we have time.
Okay.
So that not waste.
I do have one other question. It doesn't necessarily float it out, but sort of, I guess, because it seems like we're winding down for the week. Council did give us a jury questionnaire that they wanted to have sent to the jurors in advance of the trial, and we would get them before the trial starts. And I did glance at it, and it's obviously not in final form because it talks about the wrong hospital, and there are at least a few questions that I would have objections to. So I would ask that that not be done because we're 5 weeks out from trial right now. And that means we would have to finalize it, get it to the court. The court would have to send it out to all these jurors and make sure that we get them all back, because if we only get half of them back, it seems like that gives us I would rather have the same information about all the jurors and not have more information about some than others. I think this is probably a task we would have needed to embark on at least 60 to 90 days before trial.
Mr. Valentini or Ms. Green?
Written questions to the jury really facilitates voir dire and makes it much quicker and much more efficient. When jurors take home and write out their answers to questions, they're doing so without the peer pressure of anyone else. Many times during oral exam of jurors, when a juror hears another juror speak an answer that they like, they take that answer. But what we really want in these cases is for individuals to give us a truthful answer to the nature, breadth, and extent of their biases or leanings, which is what the law requires. And if they make answer to these written questions, they give the plaintiffs as well as the defendants much more information than we can get during oral exam. That can take a long time to flesh out. I have brought the facsimile questions and I have passed them. We've used them now in a number of cases, and I can say I've never had a court reject the written questions. I don't know the logistics. They could answer them in the morning that they assemble. And but if we get them in advance, that's all the better. And if you saw the questions, you'd see that they're the kind of questions that are asked during oral exam. And each juror answers them when they're quiet, hopefully, and alone, and under their own signature, they control the pen, and they're not guided by or influenced by others. That's the whole purpose of it. And it does shorten voir dire time. The last time I used it, they were able to pick a jury in the morning session. I didn't finish that case. They let me out in the morning. But that was my past experience, which I think that the plaintiffs would benefit from it, actually.
All right. Well, that's something that I've never had a request for. Never had that procedure followed. So that would be something new for me, which in and of itself is not a reason not to do it, certainly. I think from my standpoint, I tend to agree with Ms. Walsh. My concern is more of a procedural and time standpoint, of trying to get that approved, agreed to, or ruled upon, and then getting it out to jurors. I don't see having them do it here in the morning of trial is really a workable solution. So I'm going to deny that request. We'll proceed with voir dire as we normally would orally here with jurors present in the courtroom. The only other thing I would say with regard to voir dire, and I say this in all my cases, criminal or otherwise, is I take a very strict view of voir dire in terms of the purposes under the court rule. The purpose of voir dire is to discover whether there are challenges for cause under 2.512 or whether there is a basis for the exercise of the peremptory challenge. I typically will stop attorneys if I view their voir dire as trying their case in voir dire. There's nothing but hypotheticals. What would you do in this situation? What would you do in that situation? To me, that's more of arguing your case in voir dire than it is really looking for information. Do I have a basis to challenge for cause? do I have a peremptory challenge here? So I'm only saying that just so that council's aware of how I view it, and I have and will stop counsel in blood here. I view it as going beyond the scope. So just throwing that out there as a note since we were discussing blood here. Anything else in terms of just the daily schedule? Mr.
Yes, you are. Are you reserving Mondays? Or are you?
No, we're gonna go right through until we're done.
Oh, okay.
I don't have anything else on my docket during the 7 days that this trial is scheduled. Which was the reason for my first question, which is, are we going to trial? It's a lot of time for me to block off, so. Yeah, there won't be any interruption. So again, yeah, in terms of scheduling witnesses, the best that everybody can try to have witnesses ready and available.
Your Honor?
Yes.
One more question.
Mhm.
You mentioned that you have it slotted for 7 days, so if my math is correct, my calendar, my brain is correct, that would be done, ideally concluding on Friday, the 31st, correct?
Right.
Halloween.
Yes.
Okay.
And not ideally, I mean, we're gonna need to be done by that point.
Okay, that was my next question. And then on that note, given the time frame, but given the type of case, is Your Honor positing or suggesting that, the plaintiff have X number of days or hours or limitations, for example, on openings, et cetera, so that the defense is also, allotted the same amount of time with the notion of the end game is Friday, getting done? I've never really had this situation myself in all of my venues, and so I'm not really sure how we deal with that, other than trying to duke it out ourselves. I wasn't sure if the court has parameters in that regard.
Yeah, I mean, I guess when we set it for 7 days, I took that from counsel as that's how much time we would need for both sides. I don't know. That's a good question.
Okay.
Honestly, I've never had it come up in a lengthy trial where one side used up 6 days and then one side was left with 1. Usually, especially through discovery and once we exchange witness lists and everybody kind of knows how much the other side's going to take. I don't think it has to be equal because the proofs aren't always equal. So, I'm not going to stop them at day after jury selection at day 3 and say, okay, your half is over. As the trial goes on, I certainly have had issues in terms of scheduling, and one side has a witness that they had scheduled and their flight gets canceled and got to move it to, and I've generally found that counsel is able to work together on those types of things to get all the proofs in front of the jury. So I don't know if I can answer your question. I think that would have to be something that we would determine during the course of the trial. If the plaintiff's case was taking way longer than they anticipated or that you anticipated, and that you're not going to have enough time, then that would have to be a game time ruling.
Thank you.
I have also sometimes limited closings to particular timeframes based on where we're at and how much time we have left. The trial is running over and it's 3 o'clock on Friday and we just finished proofs and the jury's got to start deliberating. Then yeah, there may very well be some time limits. But otherwise I try to give counsel a fair amount of leeway. Any other questions about just the daily schedule?
Your Honor, 7 days is very ambitious. There is a provision rule 2.513 G with regard to the scheduling of expert testimony. It gives the court discretion to have the opposing party's expert present during the opposition party's testimony with the cross-examination of the opposing party's expert after that testimony. If that were the case, it's possible to get done in 7 days because we have 8 experts. For the defense. But otherwise, 7 days is very ambitious.
All right, well, I mean, if you're talking about, number one, I mean, I just don't have the option of going past that Friday. Got other matters scheduled, and I share this courtroom with another circuit judge. We have a 3-county circuit, so we're juggling 2 dockets over 3 counties and 2 courtrooms. So going beyond that Friday is not going to be an option. If you feel that 7 days is not going to be enough, then I would say there needs to be a motion filed immediately to adjourn those dates and reschedule for longer time.
I mean, can plaintiff confirm that should be done by the by the 28th?
That's Tuesday's right there in the middle. In the perfect world, we would be done at somewhere between the end of the day Monday and noon on Tuesday, but in an imperfect world,
The world's imperfect.
we take breaks and stuff, we could be into Wednesday, but I can't, that's like putting too tight of a, I don't know, I think that's asking pretty tightly. The plan is that we'll be done in the middle of the day on Tuesday, but whether that's the case or not, we'll know better maybe the day Friday.
Right.
No, we'll guarantee it.
Yeah, of course, but based on your best estimate of how much time you think that's where you land.
Yes.
Okay.
And my biggest concern is there's 2 defense attorneys, so if I think my expert's gonna be, I think my expert's a total of 1 hour and they both cross-examine for very long, then 1 hour becomes an hour and a half or 2. That's why I'm very hesitant about it is, even if there was 1 defense attorney, I'd be much more comfortable with 2 different ones, and the questioning that 2 of them could ask, that's where I could go, that's where my number could go astray. Which, by the way, will be very costly for us because that means my experts have to start holding it and coming into the next day, so. I did want to respond about this calling his experts right after mine. That has nothing to do with how long it takes the trial. That just has to do with the order of proofs. And the plaintiff's allowed to put their proofs in first. I don't want his experts coming in the middle of my case. So I would prefer that you not do that and exercise your discretion not to do that. It's not going to make it any shorter. I've only had a judge do something similar to that once, and the first witness was on for 3 days because of that. So I would be very much opposed to that.
Yeah, I've never had that. That's not something that I've ever exercised my discretion to allow. So
I was offering it as a means of economy of time.
all right, well, Mr. Valatutti, I'm gonna let you ponder that. Again, I think if you don't think 7 days is enough, then we need to get a motion to adjourn going right away. Because extending it is just not an option, as I indicated. So that's it for my list. Ms. Walsh or Ms. Sikorsky, is there anything that we discussed that we haven't already talked about? Mr. Valatutti.
Trial briefs, are we gonna have trial briefs? No. Is
I
there?
typically don't in jury trials.
Is there going to be a joint witness list?
Again, that's something that when you confer to talk about exhibits, if you can come up with a joint list, that would be great. My big thing is I just would like everybody to know the list of who they actually anticipate.
With regard to the medical records, will we have one court copy?
Again, I would leave that to you. I've had counsel who want to provide copies for each juror, as long as it's an exhibit that's admitted into evidence. I think I leave it to counsel to decide how they want to publish that to the jury.
And lastly, Your Honor, with regard to the witnesses we're going to call, the defense is awaiting the court's ruling with regard to its motion for rehearing on Dr. Worth.
Yes.
If Worth is allowed, wouldn't change the number of witnesses we call. We're anticipating on calling 8.
Okay.
Irrespective of what your ruling is.
Thank you. Ms. Greenman, anything further?
I have to ask, appreciating what you indicated regarding the timing of the trial, and the start date being the 23rd. Is there an option to start a day or two earlier if that solves the problem in lieu of trying to, file a motion to get the date?
Yeah, right now, not.
Okay.
That could change.
Okay.
I'm borrowing the 2 days at the end of the week from the other judge. So because it's a 3-county circuit, we each get a trial week in each county. So when we have more than one, it takes a little bit of.
Got it. Thank you.
But that's certainly, if we have a motion, that's something I could certainly discuss with the other judge. I mean, the last thing I want to do is adjourn this, but moving it forward today may not.
Moving it forward today would be a disaster for us, because that means all of my experts have to change all the plans we've already made with them, and so.
Yeah. Understood.
Yeah. I had one more question with regard to the motion for reconsideration. We were wondering if we could, I know a response is discretionary and it's not always allowed, but we would like to file a response to that motion for reconsideration if we could.
Certainly, if you want to do that within the next, let's say 14 days.
Thank you.
Your Honor, we object for the record. It's very late. The motion for rehearing was filed February.
Yeah, but that's really my fault. I mean, I'm gonna take points for that. So.
Did the court want to talk to the parties individually?
I hadn't planned on that.
No. Okay.
That's not something I've done either.
Okay.
If you have a reason, I'd be happy to hear it.
Well, you had asked at the beginning about negotiations and stuff, so I didn't know if you wanted to discuss that further with the parties.
Oh, no. Oh, I mean, so, no. I don't. Okay, so I will put all these things that we've discussed today into a status conference order. Let's see where things go.
Your Honor, may we
Thank
use
you
the
very much,
courtroom
Doctor.
briefly to discuss with plaintiff counsel, witnesses and the timing of the same?
Definitely. I'm going to be going off the record, and I don't think anybody's using the courtroom for the rest of the day. Do we have a
I don't.
judge on? So yeah, you're free to use it for as much as you'd like. Jordan, you don't have to stay here. Okay, trust counsel. So
Yes, sir.
Thank
you can just kind of see when they're done and just
Yeah.
lock it up afterwards.
Yeah.
Steal your TV.
I don't think you want it.